Well, good evening to you and welcome to this live program of Walter Rodney Groundings on this, the 12th day of July in the year 2020. And on this program with me this evening, I have two guests. One is sitting next to me right now, the other one is just outdoor. Uh, he'll be here in a minute, and I have here Mr. Vincent Alexander, Commissioner on the Guyana Elections Commission. Brother Desmond Trotman is going to join us shortly. But Brother Vincent, welcome.
Thank you very much, John.
We seem to be having a series of back and forths in relation to elections 2020. Now, before we get to where we are headed, can you briefly tell us how is it that we have gotten to this state of affairs so that people can, understand?
Thank you very much, Dion. I have, for some time now, without any reference to elections specifically, been making the point that we have a society that is a fractured society. We have a society in which there is tremendous competition among the various ethnic groups and between the Indo-Guyanese and the Afro-Guyanese in particular, and that there are historical antecedents to this state of things. It all has to do with the manner in which we came to this country. It has to do with the manner in which the colonial powers sought to regulate our relationships and existence. And so we've never been a cohesive society. And we have never, post-independence, been able to address the question of the kind of governance system to facilitate the fact that we are a fractured society, what I refer to as a plural society, and that there is unhealthy competition among the various groups, particularly in relation to economic life of the country, and mostly manifest at election time. There are those who will tell me that this is not a problem. The fact of the matter is that the manner of settlement of Guyanese, in every instance when a group came to this country, they came and entered into an antagonistic relationship with the group or groups which were here before. The Europeans entered an antagonistic relationship with the Amerindians. They sought to exploit them. They sought to even enslave them. Nothing cohesive about that. The Europeans brought the Africans who they enslaved, and that too was an antagonistic relationship. And even as they established that antagonistic relationship with the Africans, whom they considered not as human beings but as chattel, property, they engendered antagonism between these Africans and the Amerindians by virtue of the status they give to the Africans. These are not human beings. The Amerindians by that time were considered to be human beings. So you've introduced in society to the Amerindian people, we have some things here that have to be dealt with. And the manner of dealing with those things in terms of the role of the Amerindians was when they get away, capture them and bring them back. And if you can't capture them and bring them back, decapitate them and let's see that you have put an end to the existence of the thing. So that's another set of antagonistic relationships. And that is the way we have been settled. The Portuguese came and eventually the privileges given to them which were not given to the Africans and even to the Indians at that time. But the Indians hadn't come as yet. The Chinese came and similarly, and then the Indians came and they in a sense disposed of the Africans, interfered with their ability to command better wages and so by virtue of being substitute labor. So it's riddled with antagonism. And I don't know what expects the people who have settled in that manner and who beyond being settled in that manner have come with different values and different beliefs and different cultures to automatically just live harmoniously. It doesn't happen. It doesn't happen. And when that situation is perpetrated and perpetuated by the state, then it becomes the way in which society functions. I think that in the anti-colonial struggle, this fact was recognized, and essentially because this fact was recognized, the PPP was formed in the manner in which it was formed. When the PPP was formed, there was a desperate effort to bring into its leadership the Indos and Afros, and even Chinese, the Wongs and all of them, to make sure that the political movement was going to provide a basis for a conversation among the ethnic groups and for the confrontation with the colonizers. So it was recognized. This thing predated the political party. But the political party in its formation recognized the problem and decided, no, we can't form a party that is heavily Indian or heavily African. We have to form a party that is national. And so we have to bring together these leaders. And that's how Burnham and Jagan came together to form the PPP. And that is how the whole argument about them winning the number of seats they won and the command they got over the votes. What we don't say in all of this is the turnout of those elections. The turnout wasn't that great. But of those people who turned out, they got over 80% of the votes. Now, this attempt failed. The party became fractured. We then had two parties emerging, essentially representing the ethnic groups. Though in the leadership you had people who were from different ethnic groups, but the mass base of the parties essentially represented the ethnic groups. And so what we ended up with is a situation of a struggle for power between the ethnic groups represented by those parties. But those parties never failed to understand the need for some level of collaboration, cooperation, and even the national party, so that even in '64, when Jagan lost the elections, notwithstanding all the talk about how he lost, even at that time he was calling for a joint government. '64. People seem to forget that. In '64, Jagan called for a joint government, even though he had lost. And we see beyond '64, beyond independence, attempts between Jagan and Burnham to have a conversation about a national government. So this is a problem that we've had. And unfortunately, people who come to deal with us, they don't come to deal with our problem. Because that is our problem. They come to deal with the manifestation of the problem. They bring plaster. They don't come to deal and sit with us to try to deal with the real problem. And so elections has become a high point. It's like you have a sickness, it's chronic, so it's there all the time. And at election time, it becomes acute. So you have the chance of dying because of the crisis you're in at that particular point in time. And after elections, it tends to abate until the next elections. And so we are here today talking about election 2020. A specific moment that we need to get over. But to get over that moment in itself does not resolve Guyana's problems. And unless the political leaders have the will and the commitment to start a conversation with the real problem, then we are only resolving a moment which is likely to reoccur. And given how things are going now, we don't know how long this moment will last. We don't know this moment will in fact go back into chronic stage immediately after some declaration, given the mood and all that we've seen out there over the last 4 months. So here we're at, dealing with an election 2020, with the local people, the foreign people, the CARICOM people, the United Nations people, all of them ignoring that there's a bigger problem, and that if you don't deal with cause, you're not going to resolve the problem. And they're ignoring it, and I tell you why I emphasize they're ignoring it. The International Decade for People of African Descent Assembly Guyana, after the incidents in Borbis, wrote the United Nations. They wrote the United Nations and brought to the attention that the continuing issues had not been resolved, and that these are issues, because they're ethnic issues, they're racist issues, these are issues that the UN Committee for Human Rights has a responsibility to address. They've been here in the past. They themselves have acknowledged the problem in the past, and they were written to and said, look, this might be a moment of elections. But the real issue here is this problem. It's manifested itself, not only in the election, but in the violence we saw in West Borbis. So they were written to. Mia Motley, when she came for the first round of talks between Jagdeo and Granger, International Decade of People of African Descent wrote her as the chairman of CARICOM. She didn't even have the courtesy to respond, and said to her, look, you're here for election issues, but the issues in Guyana are greater than election issues. And if you've come to help, please bear that in mind and put that into the frame. We haven't heard a word from her and CARICOM on this matter that we brought to their attention. The people of African descent are a significant part of this country. And if we bring something to your attention, it must be taken into consideration. You can't ignore what we say to you and then tell us at some subsequent time what our problem is and what plaster you have for the problem, so that these people become a part of our problem. We have brought this matter to the attention of the United Nations. We brought it to the attention of CARICOM. We are a political party. This is the group representing the decade declared by the United Nations for people of African descent, that speaks to the African community and speaks for the African community, saying, hey guys, we know they got election problems, but there is a greater root cause. And if you are concerned about Guyana, then you have to address the root cause. Don't just come and deal with counting of votes, because the counting of votes is but a manifestation of a bigger problem which we have to solve. And if you care about us, then you have to become involved with us in relation to those greater problems. So here we are today discussing election 2020. We're not quite sure what's going to eventuate. Everybody is making a statement, but none of them, the British, who are largely responsible for the state that we're in, because it is their politics and their colonization that created this problem. The British. But now they are the judge of how we should behave and how we shouldn't behave. Right? The Americans cannot be excluded from this. They cannot be excluded. The name called in the 60s helped to perpetuate the problem. And now they've become the overlords. I'm not saying that, they must accept responsibility for the role that they have played. And if they are honestly concerned and not just looking after their own interests, then they must join with us in looking at the real problem rather than coming to placate a situation at election time.
All right, you've mentioned the United Nations, and I received an email from Brother Takumo Ugunse, and he's requesting that on his behalf that an appeal is made to all the African organizations and their leadership to write an open letter to the United Nations Secretary General objecting to the UN's statement on Guyana's elections crisis. He said we must remind the UN of its responsibility to be an independent arbiter in national and international disputes, which requires it to apprise itself of all the facts before engaging a matter. And so he said that the organizations must remind the UN that its ill-advised statement on Guyana's elections opens the way for powerful forces that are hostile to the interest of the African community and its allies. It also undermines the UN declaration of the International Decade for the People of African Descent. And he has listed a number of names: Sister Violet, Dr. Long, Sister Penda Gayan, Brother Vincent Alexander, Brother Eric Phillips, Jonathan Adams, and Brother Tom Dalgetty, and others, for them all to collectively make a statement to the United Nations in relation to... I haven't seen the UN statement, so I can't comment on it. But this is Brother Ogan's. I don't know if any of you are aware.
I have fleetingly seen something from them. I haven't really looked at his content. But what I would say is that all of the people to whom he has referred represent organizations that are integral to PADG. And in that circumstance, what I would seek to do is to convene and for us to have a second go at this matter, because we did have a first go early in the day when we wrote the United Nations Human Rights Committee, bringing to their attention the unfolding problem and seeking their intervention at that time. And having written as well to CARICOM, who haven't had the courtesy to say, yes, we have received your missive, but who have had the foresight to make statements on the election rather than to seek to address the underlying problem.
All right, so the thing is, we seem to have had an election that is taking us down a path, as you mentioned, that is widening the rift between the two major races here. Not even the two, but you have also others who have joined one side or the other. But most of them seem to be piling up their attempts at removing an administration that they're more aligned with the African community, even though the coalition is supposed to be a coalition of forces representing all peoples in Guyana. Now, we've had a number of litigations which led to the CCJ, and the view was that that matter would have ended at our appeal court. The CCJ inserted itself into the matter and claimed jurisdiction and have pronounced. But before we get to that, I mean, I know there is a strong view, and I've seen international persons claiming that the decision to claim jurisdiction was one that was out. What are your personal feelings about that?
Guillaume, before Gibson answers, I just wanted to add some things that he said.
Yeah.
Because, I mean, the main, I support the arguments which he has put forward in his initial presentation. And I just want to add that from the inception, from the birth of the Working People's Alliance, that we have recognized that there are these fundamental problems that need to be addressed, and that has to be addressed from the grassroots right now. And so that a lot of our efforts over the years have been working assiduously towards having those problems addressed, because we believe for as long as the races remain divided, the country will remain divided, and the kind of progress that should ensue will not in fact occur. And so that our efforts have been in those directions. And so far as elections are concerned, the position of the Working People's Alliance is that elections as they are conducted here will not resolve the problems that we are faced with. And so that our positions have always been that we are not interested in who wins. Once the country loses, it means that the country will go backwards. And so that the elections, as Vincent is arguing, unless leaders of this country can come together, and they have to do it very quickly in order to address the core problems, that Guyana will take one step forward and two steps backwards. And that will be a kind of ongoing exercise. So, as we approach elections 2020, it is very clear that those problems need to be addressed. The tension out there is electric, and unless we can get past where we are at this particular point in time, Guyana may very well find itself in a position, in a place that it really shouldn't be going to. And I want to add that insofar as the problems are concerned, because I have very strong views on the role that the international community have been playing in this process. Very, very strong views. Because it seems to me that they now see themselves as our new colonial masters. As Vincent correctly said, the British is responsible for where we are. And you cannot escape the feeling that their role, insofar as a resolution to this problem is concerned, is not what it should be. The Canadian High Commissioner, she's obscene. We've said that over and over. The position of the Americans is something that really leaves to be desired. In fact, I do believe that the real problem here in the society is the need for the Americans to realize their geopolitical interests in this particular period, and that there's collaboration between the British, Canadian, and European Union representatives with the American representatives in relation to achieving those positions. And so for them, the problem here in Guyana is not a resolution to the political problems insofar as the people are concerned. It is a resolution to the political problems in terms of them achieving the interests, their own interest that they have, that is foremost in their minds. And so that we have to look at this situation very, very keenly and try to determine how is it we're going to find a resolution outside of them, because they don't have an interest in us finding the kind of resolution that will allow the country to go forward.
That's a key point, but I'm wondering, if we're dealing with that, why is it that we're allowing them to have the kind of leverage that they have? I mean, it's disrespectful, it's downright, distasteful, the way, the approach that they've been taking in the matters related to this country, and I don't know why we have to accept it.
Well, there are two issues about accepting it. I'm not saying we should accept it.
Okay.
But there are two issues about that. The issue of the international world order. And when you talk about the international world order, again you have to recognize that in the era of Burnham, there was the argument for a new international economic order. And in the era of Jagan, period subsequent to Burnham, is the argument for a new global order. So we in Guyana, at the level of our post-independence leadership, have recognized the nature of the international order, which is not going to benefit us, and were integral to the movement for a new international economic order, which was largely a movement among the so-called third world countries. You had voices like Nyerere and Castro and others who were part of that. And
Gandhi, the former
Indira Gandhi, they're all a part of that. The New Left was largely a part of that as well. And then that kind of withered away in some regard, and Jagan came and went to the UN and talked about the new global order. But we are at this stage now where local people are facilitating what is happening. If we are united in terms of the protection of our sovereignty, and if we are united in terms of the role that we should be playing in world politics, what is happening would not happen. So that it is the very division we're talking about that is assisting external forces to impose upon us their will. People are seeing a commonality of interest between what the external forces are saying and what their internal interest is, and therefore they're facilitating. So we have a situation where on one hand, the world order that has emerged imposes upon us values, etc., etc. And at the same time, the internal politics and contradictions becomes the receptacle for those things at a time when it is convenient to one side or the other. And so, the honors, we continue this discussion, I would have a bit more to say about the elections vis-a-vis the role of the national community.
All right, well, so as I mentioned, we were at a point where all these litigations, I just asked, because I wanted to know how you felt about the decision by the Caribbean Court of Justice that they have jurisdiction in a matter that our Constitution says they don't.
In law, I'm advised, and I have to be very cautious, because I'm also advised I'm no lawyer,
Okay.
which I'm not. Which I'm not. But some people believe that being a lawyer is the source of all knowledge. But you could be a lawyer and be the most ignorant person. So that doesn't fly by me. But if one reads jurisprudence, one would see that there are arguments that judges arrive at their positions from two perspectives. There are those judges who decide on the position they want to arrive at, and lawyers, and then argue back to find the logic for what they want to get. Right? That's just make it possible for a lawyer to represent a thief man.
Okay. All right.
You know the man steal, but you want to arrive at the position that he's innocent. So you put that down as your marker, and then you walk back to see how you get whether technical or substantive information to bring you back to the point to say this man is steal, though he steal.
All right.
That is one way lawyers operate. That they put on a marker of what they want to arrive at, and then they find the logical argument to arrive at what they want to arrive at. The other way lawyers may work is that they have a case in front of them, and they take the case, put it into the legal framework, and work forward to see where that leads to, and arrive at a position as to where it leads to. Right? So some lawyers will tell their client, you are plead guilty. Because when I take your matter and I look at it, and I work it out, it gets to the point where you're guilty. So you got to plead guilty. So that what is of interest in this particular case, in my view, is the approach used by the CCJ. The fundamental question before the CCJ was whether they have jurisdiction in matters that are covered by our Constitution in relation to the election of the presidency and our appeal court being the final jurisdiction. That was the essential matter before them. Do they have jurisdiction in a matter where our Constitution specifies that the final jurisdiction rests with the appeal court? The CCJ did not frontally approach that question and then say, well, we don't have jurisdiction, and back off. What did they do? They laid that question aside and then claimed jurisdiction over our appeal court in matters other than the one before them. And then sought to argue that the matter before them, that the appeal court had no jurisdiction, and therefore it is not a matter that falls under the ambit of the area in which they don't have jurisdiction. And since it's not a matter that falls in the area in which they don't have jurisdiction, that doesn't fall in the area in which they don't have jurisdiction, then they have jurisdiction.
Okay.
That's what they did. So they came from the bottom to the top. They didn't confront the issue before them and say, look, Do we or do we not have jurisdiction in relation to the presidency and the appeal court of Guyana being the last court? No. So in fact, they have not ruled
On the question.
on the question that was before them. That question became a moot question because they ruled that the question before them is irrelevant insofar as the Court of Appeal didn't have jurisdiction. And if it didn't have jurisdiction, there's the apex court can hear any matter coming up against the Court of Appeal because it's outside of the area that is reserved for the Court of Appeal. So,
No, but I mean, my sense is that they're saying that that argument relates to a period before.
no. The period issue is not the issue.
No, but that they brought that up.
The period issue has to deal with our constitution that predated the coming into being of the Caribbean Court of Justice,
Right.
and the agreement of the Caribbean Court of Justice. And the Caribbean Court of Justice agreement and the law we passed in 2004, both of them sought to say that in keeping with the Constitution, that the question of the presidency, election of the president, as of that date, when this thing came into existence, has to be seen from the standpoint that there was a prior law that continues to be the law that determines this matter. And so though they have come into existence as the apex court, the extent to which we had this constitution and the extent to which in 2004 we made a law is the extent to which on the question of the presidency, issues arising after the date of their coming into existence still does not fall under their jurisdiction. They didn't rule on that. Am I clear?
But I wonder if the people out there understand what you're saying.
No, but beyond something you got to realize. You got to realize. I think that the CCJ may have misunderstood.
You think they misunderstood anything?
No, the extent to which it is the Guyanese populace is aware of the law and have an interpretation of these situations. People are now asking why it is that the CCJ went to the extent that it went to in order to insert itself in the process. And I think that once that question has arisen, it means that people are now wondering as to what the future relationship with the CCJ is all about. And so that we have to be concerned. I am not versed in the law, and so that I can't speak with the kind of authority that I would like to speak to on these issues. But I do believe that when it is that people get angry, they want to express their anger in ways in which it is that they shouldn't. Well, they should be careful about.
Yeah.
And I believe that if it is that the CCJ was located in Guyana, that its location in Guyana would have been under threat, because they have handed down a ruling which to a large segment of this population had no right to be put forward. And so that and now people are also saying, look, why it is that this CARICOM is a community of so many nations, and in fact it's only 4 countries are
part of
the CCJ as the apex body. And so the people are asking questions, look, are they politically aligned? Are they taking directions from forces outside of the Caribbean in order to arrive at decisions that will impact the future of the Caribbean? Those are questions that are being asked. And I think that what people are confronted with at this particular point in time is not something which it doesn't make the CCG an attractive body to a large segment of Guyanese and to other countries which are not related to that thing at this particular point in time.
We need to recognize, I would not be the one to say And I think that the people in the seat should get bribe or take money from anybody. I would not go down that road. I like to deal with evidential issues.
Yeah.
But the fact of the matter is that if one looks at the judicial systems are manned by human beings. They're manned by human beings. And there isn't a human being who does not have a subjective aspect. Once a human is involved in something, there is a subjective element. And I make a differentiation here without going into detail between subjectivism and subjectivity.
Okay.
But there is subjectivity in anything that a human being does. I say that so we can understand the nature of courts and the decisions that they make. And I want to use the American system to exemplify what I'm saying. In the American system, we know the judges are appointed by the Congress, and that's the highest, the federal system, but that the appointments are initiated by the president. It comes through the Congress. And there's no contestation in the American system that one party puts forward judges who share a common ideological perspective with that party. Another party puts forward judges similarly. So you know if this party is an anti-abortion party, and they put forward a judge, that if he has to deal with a matter, he will deal with it in the framework of their anti-abortion perspective. That's the reality of the American system. Nobody questions that reality. I'm using that reality to say that, look, in any legal system, anywhere where you have judges, there will be some ideational basis that is subjective that will then inform their search for an objective solution to the matter. And so the Caribbean Court of Justice is not exempted from that general framework of how our justice system will work. And that is why one judge can make one decision and argue it well, and another judge makes another decision on the same matter, makes a different decision. But the extent to which this is the apex, this is the final place. And so there may be different views on the matter, but the apex is the place where it is finally determined. And their subjectivity in the context of the search for an objective decision is what prevails.
No, you just pointed out that the question that they actually were to deal with, and that was one of the issues that I've seen many of the people, not only from Guyana, but from across the world, even some of our own people who are overseas and so on. They've been making the point that there was one issue to be dealt with initially and substantially, and that issue, you said, would not have, they didn't deal with it. So where does that leave us in terms of, jurisprudence in relation to that particular matter and the jurisprudence of our appeal court? And
well, the only possibility we have is if at some subsequent time there is some similar matter that court itself deals with it differently. That's the only possibility we have. But they've established a precedent.
And be bound.
But the precedent, what is interesting, is that the precedent is not specifically in relation to whether they have jurisdiction over our appeal court on matters pertaining to the election of the president, which has two elements in it. One, the qualification of someone to be elected, and two, constitutional interpretations in relation to the election of the president. They have not pronounced on that. And so for all intents and purposes, we can maintain the position that they don't have the jurisdiction, because they have not set a precedent in that regard. They've said, we didn't have to deal with that matter because that is not the real matter here. The real matter here is these people didn't have jurisdiction. And since they didn't have jurisdiction, we got jurisdiction over them in instances
Oh boy.
other than the one in which they don't have jurisdiction.
Oh Lord have mercy.
What's the unfortunate thing about all of this, Leon, is that there's no appeal. There's no appeal from
I know.
But that's the apex.
because it's the apex
That's
one.
the apex.
But while it is true that they've handed down a judgment which they're asking you to
accept.
accept, generally, when apex bodies hand down decisions, there are disagreements throughout the land about some of the decisions, because remember the point that Vincent is making, those decisions don't necessarily conform to what other people because they represent a particular view, and other persons have different views, and simply because there's no identification with the two, people don't. People are bound by the decision, but don't necessarily accept that the decision is correct. And that is why, from time to time, look at the U.S. Supreme Court. From time to time, there are challenges to Roe versus Wade, the abortion issues, because even though they handed down a decision, people are now challenging those decisions in different ways.
Let me make a further point
Okay.
about the CCJ. Guyana finds itself in a peculiar situation in the sense that Guyana's jurisprudence is not at one with the jurisprudence of the rest of countries
in the Caribbean.
in the Caribbean. Our jurisprudence is different when we come to land law, for example. And so, for example, when you go to your within law school, the Guyanese have to sit in a separate class with a lawyer, more than likely a Guyanese lawyer, to deal with the question of land law. Now, our constitution is no longer a typical Westminster constitution. And these guys are, for all intents and purposes, versed in Westminster constitutions. We have a hybrid system. Our electoral system is hybrid. Our constitution in itself is hybrid. It has elements of the typical Westminster constitution, but it also has elements of constitutions which are based on executive presidencies. And so they are themselves not necessarily original thinkers on the question of the Guyana constitution, and may well be importing into our constitution perspectives that are essentially perspectives of the Westminster system. So there are all of those issues at play, but the fact of the matter is we've signed on to the CCJ for good reason, I would say, and therefore we're trapped.
All right, so they've made decisions. There's still argument about what the CCJ did say and what they didn't say. What is your perspective on what they actually
Right, well, good.
said?
Good. So, if you read the decision, that becomes another problem.
Okay.
Becomes another problem. They, in a sense, argued that the Esdin Davis case oscillated around the question of the order 66 of 2020 and whether one should insert in the Constitution valid votes, which, from the Esdin Davis perspective, would then allow for the order to be read in such a manner as not simply to see valid votes from the perspective of the representation of the People's Act, which deals with valid votes in a very simple way. It says, look, people vote, you're counting those votes. At the time when you're counting those votes, you have two categories of votes: valid votes and reject votes.
Okay.
And once you've put aside the reject votes, everything else is valid.
Okay.
Of course, the court demonstrated its lack of total knowledge of our system, when in that articulation they refer to spoiled votes. Spoiled votes does not come into that argument. Because when you go into the ballot box, there's nothing like a spoiled vote to be counted, to be discarded, to be taken into consideration. A spoiled vote is, or in fact, a spoiled ballot, not a spoiled vote, a spoiled ballot. It's a ballot which somebody makes an error on and then requests a fresh ballot. That ballot is therefore taken out of consideration, and the person would have exercised his or her franchise using a fresh ballot. And the only purpose that spoiled ballot serves is for reconciliation of the ballots, to make sure all the ballot papers are accounted for. But they mention that in the course of speaking to a spoiled vote, to speaking to a valid vote. So it shows you that they do not have a complete understanding, even of the subject matter which they're addressing, but in the apex. So their judgment seems to take you in varying directions that has left us in a quandary as to the application of the judgment to the matters before us. If you argue in your judgment that a valid vote has been determined on March the 2nd, and you also argue who were the persons present for the determination of that valid vote, and that there could be no contestation about those valid votes, which were determined on March the 2nd, then you cannot tell us
that they recount.
To use the recount for the basis of a result, because when we were doing the recount, under our understanding of things with an order, we address this question. And here, I'm not referring to the question of the dead or to the migrants. There were instances where we looked at votes and made a determination in the recount as to whether they were reject or not. And in fact, the interpretation of reject changed 3 times at least during the recount. So that you now have a situation where if they're saying that the valid votes were determined on March the 2nd, by a definition that they give coming out of the Representation of the People's Act, and you look at what we did for 30-something days, it's at variance, and therefore the actions of the recount would have corrupted the count.
And their interpretation of what it
And
should
their interpretation. And so it then flies in the face of their interpretation for them to turn around and say, use the results of a process which by their argumentation is corrupted to determine the final results. And that is a kind of conundrum that I think caused the CEO to pose the question. Because the chairman in her instruction specified, having said in the first paragraph that the chief elections officer is a servant of the commission using section 18 of the Election Laws Amendment Act. So that's the first thing she said. Having gone on to talk about 177, and this has to do with the election of the president, and then going on to talk about 96, which has to deal with the whole question of the recount. She then goes to say he must use the recount that flies in the face of those, particularly 96, previously referred to in her letter. And so there is conflict in what he's been instructed to do. And that obviously will lead to the issue of what is it you are really asking me to do. If on one hand you're saying that the court has ruled this, and on the other hand you're saying that the court say must use this. So that there are those problems which have arisen, for which it's now become a power play. Because in the commission, for all intents and purposes, it's not necessarily logic that prevails. It is power that is manifest. How many votes? You have 7, 3 and 3, and the chairperson.
So the idea of the CEO being rude.
That's an absurdity.
No, no,
The CEO asked for clarification.
Uh-huh.
The CEO asked for clarification. And I saw nothing wrong with the request for clarification because I myself, if I were in his shoes,
you would have asked.
I would have asked for clarification.
No,
And
but-
see, Dion, something you gotta understand. When the CEO wrote his letter to the, in response to the chair, and he said, clear the issues. He was acting within his right. The law allowed him to do that. Vincent will tell you that we had, the PPP commissioner said that he was rude. As a creature of the commission, he had no right to raise this matter, the question of clarity with the commission. And of course, we had to beat them back. But there's something which this lawyer Gonraj seems not to understand.
Not this lawyer, the lawyer.
The lawyer Gonraj
There's no other.
seems not to understand. Because if it is that you follow developments in the post-Second World War trials, the Nuremberg trials, and on all of the trials that had to do with human behavior since then, what is accepted internationally insofar as jurisprudence is concerned is that you can no longer step forward and say as part of your defense that you did not, you were given orders and you had to carry it out. Because a lot of people have been jailed and hanged because they did not act in relation to those illegal orders. So when the CEO said, you know, I have these concerns, he was saying, as far as I'm concerned, you're giving me illegal instructions and clarify for me the legality of what did you say. That's what he was saying in effect. So all of those clowns who were saying and who continue to say that he exceeded his authority clearly are either unaware of what is the accepted position in relation to jurisprudence, or they know it and have proceeded to ignore what is acceptable.
All right, we only have a few minutes. This discussion will definitely have to continue. But I mean, the fact is that no clarification was given.
No clarification.
No, okay.
And the CEO has proceeded to...
The CEO's response was that I have not been given clarity because, in fact, we adjourned on the understanding, and the chairman said, he's asked for clarity, we will give clarity. We'll give clarity. We discussed the matter among ourselves. There were different views. I don't know what her summation was. Formally, we adjourned for her to prepare a letter to give clarity. That letter gave no clarity. All the letter said is what I said to you at the beginning is clear, and that stands.
Okay. And that is clarity?
And that is the supposed clarity. And so the point that Trotty is making is very relevant.
Okay.
The point Trotty is making about the war. A lot of people have been found guilty for war crimes. When they try to use the defense, they carried out an instruction. And the principle now, the standard is that you're not obliged to carry out an illegal, unlawful instruction. Right? He has gotten no clarity, and so he says, in the absence of clarity, this is my understanding, and therefore I am producing a report in keeping with my understanding. You have not clarified the matter, and so I have had to resort to my own understanding of the matter, and here is my report in that regard. And that's what's before us, and that is what we will have to deal with when we meet.
Presumably. I say presumably because she has had a report from him previously,
Yeah.
which she has refused to present to the commission.
Well, this instance is a little different, Shorty. She sent it to us.
Yeah, this
The
time she
report
sent
has
it
been
to us.
circulated to the members of the commission.
All right, I mean, just for Sister Donna Harcourt, in the event that, well, you were to deliberate on the report, and she had asked if 72 hours pass, what happens if there is no decision in terms of swearing in the president on the basis of the report? What happens?
I don't think that anyone else could take it upon themselves to swear in the president.
Okay.
And so one may be in default, but it does not strip one of the responsibility. So some of these provisions are what is referred to, and again, let me say I'm not a lawyer.
Okay,
but
they tell you that, no?
Oh yes.
They keep telling you.
They keep telling me that. I'm not a lawyer, but my only response to that is that I'm not stupid. I'm not stupid. I'm no lawyer because he got some people, would tell me that I must just follow him blindly.
All right.
And some of these, the lawyers say that some of these things are mandatory, and some of them are directory. Right?
Okay.
Some are mandatory and some are directory. So some are an attempt to say this is how's the best way to do it, and some is to say this is the only way it could be done. So this may well be a directory provision.
All right.
But I'm no lawyer.
Okay. Gentlemen, I've been ordered to close off, but we certainly have to, if the time permits you next week, to come. And I know, let me apologize to Mr. Hamilton Green. He's been on my back asking to come on the Groundings. I have not given up on you, sir. I'm going to, get you here on the Groundings so that we can discuss all these issues that are germane to the elections and so on. All right? The Venerable Hamilton.
When you get him, you have to ground him first.
I'm going to do that. But ladies and gentlemen, it's really been a pleasure being with you once again. And I want to thank these gentlemen for bringing some clarity to a number of the issues that would have arisen out of the CCJ's decision. I know that there are still a lot of questions that are needed to be clarified, and I'm hoping that they can come again next week so that we can continue to have the populace better informed on where we are.
Dion, we would, with great pleasure, seek to be here when called upon. God spare life.
Well, to the folks out there, do have a good night. See you next week. Same time, same channel. For another program of Walter Rodney Groundings. Gentlemen, thank you again.